Guyana-Venezuela border controversy is a story that shapes our nation's past as well as its future.
And we cannot talk about the past without talking about what happened in 1899.
In 1899, an international tribunal sought to resolve this border controversy. Did you know that Venezuela originally agreed to this arbitral award, which marked the Essequibo River region as part of Guyana's territory?
The Essequibo region, rich in culture and resources, is an integral part of our Guyanese heritage. Years after the arbitral award, Venezuela decided to reignite this controversy. And then, in 2015, when we began our plans for oil production, they ramped up their aggression.
Ongoing dispute, the Guyanese people have continued to thrive, upholding our sovereignty as well as our rights.
And Guyana has consistently sought lawful and peaceful resolutions of the claims made by Venezuela. We have turned to international bodies and diplomatic channels advocating for justice and adherence to the international law.
Here's what the Attorney General, Mr. Anil Nandalal, had to say about the many routes Guyana has been taking to diplomatically resolve this issue between ourselves and Venezuela.
We are meeting here to discuss perhaps the most important question that has ever faced this country since its birth as a nation state in 1966, May 26. It has been described as an existential threat because that is what it is. There is a claim by our western neighbor, the Bolivarian Republic of Venezuela, that it owns more than 5/8 of our territory, the entire resource-rich county of Essequibo. Those who spoke before me admirably laid the factual foundation spanning over a century and a half in setting out the historical evolution of this claim. But I will focus, using the broad foundation laid, I will focus on a couple of issues that I believe should be etched in your memory as we bring countrywide public awareness on this important issue. So, it all began after Venezuela gained independence from Spain. At that time, Venezuela was a newly birthed country, and whatever may have been the reason that led them to believe that British Guyana at the time, a colony of Great Britain, was in physical occupation of territory that was theirs. At that time, Venezuela was a newly birthed country. Britain was a mighty colonial empire. So Venezuela ran to the United States, and that is where it lodged the complaint. At that time, many of you are doing history, and you would have known about America trying to do its hegemony, etc., the turn of the 19th century. It coincided with what you may know as the Monroe Doctrine. So, building on the platform of the Monroe Doctrine, Venezuela went to the US to say, look, big, powerful Britain, through its colony Guyana, is occupying a massive space of land that belongs to Venezuela. We are a recently independent country. We can face the might of the British Empire. Please come to our assistance and intervene. And it is in those circumstances that America intervened. Venezuela, so firstly, it was initiated by Venezuela. They chose the United States of America to be the one to initiate the process on their behalf. They sat at the table with the US government, with the British government, and they worked out the modality on how this issue will be resolved. They chose the method of arbitration. Arbitration, many of you are doing A-level law, I understand. Arbitration is a legal process that two parties freely and voluntarily sign on to. And when you sign on to that process, you bind yourself to the process, and most importantly, you bind yourself to the outcome of that process. Venezuela sat there and worked with its two governments on this arbitral mechanism. The arbitration was established. Venezuela again sat there and participated in the choice of arbitrators. 2 from the United States, 2 from Great Britain, and the 4 would choose a chairperson. And the 4 did that in the form of a Russian jurist. Venezuela again was very well part and parcel of that. When the award was made, Venezuela celebrated a victory, and perhaps rightfully so. Why? Because Venezuela benefited from a landmass through that arbitral award that is 5 times the size of what we know as the Cooperative Republic of Guyana, including Essequibo. They got 5 times more. And that is why the president of Venezuela's brother at the time made a public statement that he is so overwhelmed by the award that it has realized his lifelong work. And the Venezuelan government celebrated it as a victory. They moved it to demarcate, they used it as a basis to organize the boundaries of Venezuela, as Comrade Carl Greenidge has explained, including boundaries with Brazil. Not boundaries with Guyana alone, but boundaries with Brazil. They went to their parliament and they put those boundaries into their laws, and they commissioned maps of Venezuela showing those boundaries. They did stamps, they did national symbols, everything nationally done to embrace that award and recognize what that award says, and they implemented it in every material way possible. And that was the position for 60 long years. For 60 long years, that was the position. No one had an objection. British Guyana lost its territory. We never said a word. British government never said a word. And life continued as normal. The events began to change when in 1960, the General Assembly of the United Nations passed a resolution that called upon colonial powers to recognize self-independence and grant independence to dependent and colonial territories. That led Premier Dr. Cheddi Jagan to write to the General Assembly in 1961 to request independence of British Guyana. And then for the first time, since 1899, Venezuela formally lodges a complaint first to the U.S. State Department, which was transmitted to the UN General Assembly. And the basis of their complaint was not a legal one then, it was a moral one. And that is when it said for the first time officially about this letter from this lawyer who 40 years after, it was discovered that he wrote a letter which he directed in his will that that letter must not be opened till after his death. So after he died, they opened the letter. The letter had some spurious allegation about corruption against the judges. That the British judges conspired with the Russian judge to some James Bond kind of conspiracy theory to give away the border to Guyana, some foolishness like that. And the man said the letter must not be opened till after he dies. So you can't question him. So you know we have a saying in Guyana, dead men tell no tales. Well, there was one dead man who was telling a tale. Or HBO used to run a series called Tales from the Crypt. That was a tale from the crypt. So that was the basis. And they went to the United Nations and they objected to Guyana's independence. And that presented the platform for the Geneva Agreement. Because British felt at the time, first of all, it was never intended by the Geneva Agreement that this border issue must be reopened. That was never it. The Geneva Agreement is crafted and predicated upon the common assumption and the factual and legal basis that this issue has been comprehensively and conclusively resolved and determined by the arbitral award. That is the foundation upon which the Geneva Agreement was negotiated and concluded. It was simply an avenue to allow Venezuela an opportunity to present this controversy that it claims it has. That was all. And even before the Geneva Agreement was signed, from 1962 to 1966, they got 4 years to bring to the UN credible evidence to support their allegation of this fraud. They never did. British felt that to send Guyana into independence with this big powerful Venezuela next to it, with this issue hanging in the air without a dispute resolution mechanism in place, is an unsafe thing. And it is in that context that the Geneva Agreement was signed. The Geneva Agreement, therefore, simply is the mechanism by which we must find peaceful resolution of this. And Mr. Carl Greenidge has outlined the various processes. And all the processes are in the empowering hand of the Secretary General of the UN. That is what Venezuela agreed to in the Geneva Agreement. That the processes must be done under the auspices of the United Nations Secretary General. And that's what we have been doing from 1966. So we had a mixed commission. They failed again to produce any evidence that can sustain the type of allegation they were making. Then we moved to the good officer policy mechanism. That did not yield the type of success that we expected. And after all these processes failed, we went back to the UN Secretary General to say, look, we come here for you to recommend another mechanism. Because that is the power that you have. That is what both parties gave you the power to do. And it is the UN Secretary General that says, look, go, and as Carl British pointed out, they give both countries an opportunity to object to the recommendation. And what was the recommendation? Go to the UN principal judicial organ, the International Court of Justice, to resolve this dispute. And that is where we are now. Now, an important thing is, and to show, to give credence to what Dr. Mark Horton spoke about the bullying. This border issue, as you have heard, has been hovering over us since 1962. And at various periods over the last 50 years, it would have gained different momentum and assumed different critical stages. But where we are now is we are seeing its highest escalation. And why? This latest invigoration of energy into this matter, which has catapulted it to where it is now, is simply because we discovered oil in large quantities recently. It is a quest for Guyana's resources. We were not that attractive before the oil discovery. In fact, as I said to Queen's College yesterday, President Maduro's predecessor, President Hugo Chavez, has been a good friend to our government over the last 20 years prior to his demise. He was asked about this exact question, and he said it was an imperialist ploy. He said that it will assume the back burner on Venezuela's agenda. President Maduro himself came to Guyana. He came to Guyana as a friend. We all, I believe, went to the airport and welcomed him and so on. This is our neighbor. We concluded major agreements with them over the last decade. One that comes to mind is the Petro-Caribe agreement. What suddenly changed? The discovery of oil. And in all their propaganda, they describe Essequibo as this resource-rich, madly referred to as some province or state of theirs. So, at the court, they have been, first of all, they don't want to submit to jurisdiction. They exercise what you call their sovereign right. And the court said, listen, you signed this Geneva Agreement. You participated for 50 years on the processes of this Geneva Agreement. It is the Geneva Agreement that recommends the court. How can you come here and say that you are not submitting to the jurisdiction of the court when you have already done so by signing the Geneva Agreement? So that argument was thrown out. Now they have to file what they call, what is loosely called their defense to our claim. And they have not been able to do so. You know why? And why they are reluctant to go to court? And why they're perhaps taking these drastic and what can be obviously provocative steps, such as this referendum and the question that the referendum asked, is because they cannot go to a court of law or any tribunal of substance and present a case to support their allegation. They can't. So they invoke rhetoric, they invoke misplaced, say, patriotic and nationalistic sentiments to mislead the masses in Venezuela, to tell them all kinds of things. And that's where we are. We have approached the court as a result of this latest act of this referendum to say, court, we are before you in this matter. Venezuela is before you as well. And here it is that they are taking steps while the case is going on to do things that will affect the outcome of the case and that will derogate and transgress your jurisdiction, because this court has been placed exclusively in charge of the determination of this matter. And that's where international law has placed it. and an agreement signed by Venezuela has placed it. To run on a track that collides with that is not only disrespectful to the court, but it's a violation of international law and an attempt to subvert international legal order and international legal process. And that is why we have been able, as a country, to secure widespread support and solidarity in this region and beyond. The Organization of American States, the United Nations, of course, the Commonwealth, the CARICOM, and all major countries in this hemisphere are standing with Guyana. Why? Because we are on the side of righteousness, we are on the side of diplomacy, we are on the side of the rule of law, we are on the side of justice. And that is why when we say that Essequibo is ours, it's not an empty rhetoric. It is a pledge and a plea that is grounded in fact, history, law, justice, diplomacy, and all the international concepts.
As Venezuela's referendum approaches on December 3rd, it is important for every Guyanese to understand the stakes. This decision could have a significant impact on our border and our future.
So let's educate ourselves. Knowledge is power. Understanding our country's history and rights is our pathway to power and strength.
Our beautiful land, from the Rupununi savannas to the shores of the Atlantic, are a testament to our resilience and diversity. And so it is our responsibility to not only protect, but cherish it.
Remember, all 83,000 square miles belong to Guyana. We are unified, one people, one nation, in our history, culture, and our destiny.
And for Guyana and for our future, let's stand together in unity and pride. Essequibo is real.